So we will now hear from Ms. Samantha Beers. Ms. Beers has over 33 years of experience practicing as an attorney at the United States Environmental Protection Agency. In her time with the EPA, she directed Region 3 and focused on environmental justice programs. Ms. Beers' experience allows her to provide a unique perspective in today's discussion, as she will lay the foundation for what it means to be an EJ community and why this community is important to environmental rights nationally.
So while she's getting set up, I want you to shake out a little bit. I know it's hard to sit so long. Those of you that are still in law school are probably used to it, but I'm not anymore. And I just wanted to make a slight amendment. So I was the director of the Office of Enforcement, Compliance, and Environmental Justice. You'll notice the first word was enforcement. So I helped to manage the 17 statutes in 5 states in the District of Columbia. When I put my hand up in 1992 and said to our then regional counsel, Marcia Mulkey, that I wanted to do environmental justice legal support, she said, that's okay, do it on your own time, don't let it cut into your real work. So I never had the mantle of being in charge of EJ. And you've heard a lot today about all the cuts and the change and the difference. If I had time, I'd tell you how many times I was zeroed out for doing EJ at EPA. I'm no longer with EPA. I chose to leave on February 9th of 2024, and I joined Steptoe and Johnson. My law practice there has some traditional environmental work, like helping with permits and doing litigation and giving policy advice. I also am now at sort of the cusp of the environmental issues raised with energy transformation. And of course, I still do a lot of EJ. I don't call it EJ. And for most of my career, I didn't call it EJ. What did I call it? Sustainable economic development, community action plans, outreach, how to manage comment periods for permitting efficiency. These are all words we might want to think about, because the business case for environmental justice remains the same. You, as a business in America, a corporation is a person. And if you're a person, you live in a neighborhood. How do your neighbors feel about you? Do you want your grandma to live across the street from that facility? If not, think about being a better partner in that whole community. I'm going to set the stage by just giving an overview of what EJ is. I have been so frustrated since 1992 hearing people talk about EJ and getting it wrong that I want to take a deep breath and start over with what it actually is. It's not DEI. And how many times have I heard in the last 4 years that those two terms being used interchangeably? So let me give you the quick before I go to the slides. DEI is how you treat each other. It's whether or not you're promoted in the workplace based on what you look like, who you love, what race you are, what religion you are. That is not the same. Environmental justice is based on science, not fairness. What's the science? It's public health impacts from the quality of your air, the quality of your water, the traffic, the lack of other health indicators, which we're going to get to. So you need to think about when someone says, well, DEI and EJ, I don't care what your political party is. I've heard it wrong from both sides, and you heard it wrong once today already. DEI is about fairness and equality and how you treat each other. EJ is how people use their land and their environment and whether or not it has negative impacts on their health. It is quantifiable, it is reproducible, and it is valid. So no matter if you get outed or end or zeroed out or not zeroed, nobody cares. If it's still real, and it's going to keep coming back, right? So what is environmental justice? The old EPA, starting in 1994, Executive Order 12898, defined environmental justice as the fair treatment, in bold, and meaningful involvement of all people regardless of race, color, national origin, or income with respect to the development, implementation, and enforcement of environmental laws, regulations, and policies. Now, we're in a law school environment, so I'm going to tell you why those things are bold, although I bet you already know. They're bolded because there have not yet been sufficient court decisions really defining what those things are. What does it mean to be fairly treated? What does it mean to have meaningful involvement? Is that the public comment period at the end of a judicial case where everyone hopes there's no comments and then you have 30 days to respond to 1,800 comments and you're furiously doing them all at once? Is that meaningful involvement? If we already decide on Thursday night we're having meatloaf, and I've got the only recipe, and I tell you, Do you feel involved? I'd argue you didn't. It's a one-way communication. Does one-way communication ever allow for meaningful involvement? I liked it when I was parenting, especially teenagers, but I'm not sure that that's meaningful involvement. I'm not sure people had the chance to be heard. I'm not sure that what they shared with me was integrated into my decision-making process, right? So when you start to think about EJ, think about what happens. Now, I chatted last night at dinner. We were at Christopher's, which was my old neighborhood bar, because I lived on Midland Avenue in St. David's for 30 years. So when things happened on Midland Avenue, big meaningful involvement, lots of meetings, your councilman went door to door. I wonder if that happens in Chester. So are rights given to some people, not to others, based on their zip code? My old neighborhood, the big Wawa's going in, there's a lawsuit, there's people chipping in for this, there's that. I think people wake up in Chester and there's something new going on across the street and they're not sure they were ever told. So think about environmental justice, not as fairness, but whether or not the activities will have a negative implication on people's health that is quantifiable, testable, and that you can point to. How many children in that neighborhood have lead in their blood? How many children in that neighborhood have asthma? These are the sort of things you need to think about when you think about EJ. Again, not fairness, which doesn't mean that what people are living with is fair, but that's not the crux of the issue. It is not DEI, and nothing's wrong with DEI, but DEI is a completely different body of work, right? So I put this together because I had 21 years of standing on fields. Those of you here from Radnor Township know that we start our sports early and often. All of my kids did one sport a season. So I thought this is the best way to get people to understand what different terms mean. It makes me crazier than normal when terms are used interchangeably that should not be. So let's start at the beginning. Everyone decides we need a fence around the field. That's true wherever you go. You want to keep the balls and the kids in and the dogs and the cars out. Right? So there's a fence. The guy who designed the fence, perfectly good heart, wasn't meaning anything bad by it, put together a fence. He happens to like wood, so he did a wooden fence. Then we have the three people watching it. This is equality. This is the assumption that everyone will benefit from the same support, right? So there's a wooden fence. The individual on the far left doesn't need the box, but he's enjoying it. He's watching the game. Person in the middle needs the box. She can see just fine. And the individual at the end can't see even though they gave her a box, right? So let's go to the second one. What's equity? Equity, they took the box from the guy on the left and they gave 2 to the girl on the right, and God knows he's still mad about it. He talked to everyone about it. He wrote articles about it. He's running for office on it. Oh my goodness, I've been speared. He didn't need the box. We all know he didn't need the box, but darn it, why'd you take it away? That didn't seem right, right? Again, EJ is not fairness. That's the concept of affirmative action. We know how that's gone in this country. This is my favorite. This is the concept of justice, because there was a root cause determination made about why anyone needed a box, and what was the point of the fence in the first place. If the point of the fence was to keep people from seeing what was inside, you got the right fence. If the point of the fence was to keep the kids and the balls in and the dogs and the cars out, you use the wrong material. And if you switch the material, nobody needs a box. So everybody take a deep breath. That is environmental justice. It's about looking at the root cause of an issue and saying, are the assumptions I made about how someone uses their land correct? And if they're not correct, what kind of fence should I have? I'm going to give you a real quick example before we go to the next slide. So years ago, when I started at US EPA, I guess it was maybe 1995, I was doing litigation in federal court in the Northern District of West Virginia, right? And at that time, the DOJ attorneys were not as fluent in RCRA, Resource Conservation Recovery Act, as I was, so I was sitting in for the first chair. And I was taking a series of depositions, and I was asking questions of the toxicologist hired by the refinery. And I said, well, what's this based on? He said, come on, it's based on what everyone knows it should be based on. It's based on a 187-pound man who eats fish every Friday. Now, if you work with Native American communities, with Asian communities, or with communities that are into subsistence fishing because they don't have the money for protein, is that normal or is that reasonable? Do you know how people use their land? So well-meaning people sat in a room and decided that their experience was the experience when they decided how to protect you. Does it protect pregnant women? Does it protect children? How about short people? If you have a community of people that generally weigh between 99 and 130, pick the ethnicity on your own. I think you can figure it out. Are you being sufficiently protective? Again, EJ is not about fairness. EJ is not DEI. If you take nothing else from this entire discussion, take that. It's about quantifiable public health effects that are deleterious, right? So what's the movement? Now, the movement started in the 80s. It's a grassroots movement. It didn't have government. Most of the most meaningful issues had nothing to do with the federal government. The fathers and two women that were involved in the beginning of the movement, when I first got involved in 1992, when I walked into those rooms, it was largely men, some men of color, and two women, both black women. And they were very, very involved in the movement. Started with the United Church of Christ study, written in part by Charles Lee, who I guess it was about 2000, 2004, went into US EPA as a senior advisor. Prior to that, he was doing this sort of policy work for the United Church of Christ. So this is a movement that seeks to meaningfully involve those who are politically disenfranchised. Remember, I knew who to call when I'm upset about something in my neighborhood. Does everybody know who to call? Probably not. Does everybody get their phones answered? Probably not. Or economically disadvantaged from making significant changes in their own community. That piece speaks to, do you rent or own your property? What do you have a right to know? You guys know that when you get your water bills, we are students. Those of you who aren't students and own your homes, when you get your water bills, there's a flyer in there that tells you about your water quality. If you rent and you're not paying your water, you don't get those. So there's already different rights about knowing what's in your water based on whether you own or rent your home, right? It strives to mitigate environmental racism arising from the abuse and neglect of the local environment. Thank you so much for talking about the rights of people here in Pennsylvania and how the rights of the native environment and all Pennsylvanians are supposed to be honored. I think that's a nice backdrop for us, and seeks to systemically address and redress disproportionate burden. Why is this group more heavily burdened than that group? Again, this goes to that concept of whether your life expectancy should be dictated by your zip code. When you remove for accidental death, violent death, and drug abuse, you still have a huge difference in this country based on your zip code and your demographics. Is that okay? So that's my contact information. I had another slide that we didn't add, but I'm going to just really briefly talk to you guys about a couple quick things. I don't want to go into anyone else's time, but I want you to think about what I tried to add is, you're starting to hear about changes and what's going on and whether or not it's okay. Because the environmental justice movement was a grassroots movement, and because it has been carried most meaningfully for many years by people outside federal or state government, and because it can be quantified in health effects, infant morbidity, all-cause cancer, low infant birth weight, asthma rates, as well as social determinants of health. How far are you from a hospital? How far are you from dialysis? Can you get produce? Those sort of factors come together and can help predict your life expectancy. So when you look at that sort of thing, and you look at who has this movement been, whose hands have been in it, it's mostly outsiders. It's multiple stakeholder groups. And I have to give a lot of credit to some of the work done in the Biden administration, where a lot of the large environmental organizations began to notice environmental justice, began to invest in environmental justice, began to get funding for environmental justice. And I am hopeful that the traditional environmental justice groups, together with the environmental groups, and the group we're not talking about yet, but we need to, which is the important role that industry plays in protecting public health and the environment. I have a lot of industry clients, and they have no less passion for this topic than I do. So we need to think about having our table be large enough to invite people back in, so if the federal government steps out, like they appear to be doing now, that concept is advanced by other stakeholders, which is where the movement started and where it will continue to thrive, in my opinion, given the chance. Thank you.
Thank you so much, Ms. Beers. We will now hear from John Dernbach. Much can be said about Mr. Dernbach. He's both nationally and internationally recognized as being an expert on sustainable development, climate change, and environmental law. He is the founding director of the Environmental Law and Sustainability Center at Widener University's Commonwealth Law School. So much more can be said about Mr. Dernbach, and like I said, the biographies are on the website. But as it relates to today's conversation, which is an important one, it is important to understand that Mr. Dernbach has been instrumental in how the Pennsylvania courts interpret the Environmental Rights Amendment today. In his presentation, he will explore how the ERA offers protection and how it offers protection to environmentally disadvantaged communities.
So hi, everybody. It's good to see you. It's good to see a lot of people in the room. I've been to law school symposia where there's maybe half or a quarter as many people as there are here, and you have a lot of other things you could do with your time, and it's a pleasure to have to come and have a good audience. And thank you, Ambria, for the kind words. What I want to try and do is build on what Meg Murphy said in her keynote. And I want to just note something here. It's, I don't know if it got said in her introduction. I don't think it, I don't recall. She's a graduate of this law school. And she has a wonderful story. And she came back here some years later, I won't say how many, to speak to you all about work that she's done and that she's passionate about. And I'm guessing that there are people in this room who are going to be invited back to this law school in a similar capacity in the future to talk about the work they've done for environmental protection. And I'll just sort of note that for you because I remember as a law student thinking, geez, there's all these problems out there and like, what can I do? And trust me, everybody you've heard today has a story. Everybody about what they've done, and everybody here at one point or another, I guarantee you, was sitting in a place sort of like yours or in a property law classroom or other classrooms thinking, well, gee, what can I do? So there's a lot of work to be done, and I just encourage you to think about what role you can play in doing that. So what I'm going to try and do is sort of, I've done a lot of writing and a lot of thinking about Article 1, Section 27. I'm going to, in just a very few minutes, do a very narrow cut and look at the environmental justice part of this. You've seen the Environmental Rights Amendment already. Meg showed it to you. I want to break it into two parts because basically the courts do now. This is the remarkable new thing that we have that she talked about. The revolution that Meg talked about that is so important here is we went from a three-part test that worked as a substitute for the text of the amendment to actually applying the text of the amendment. And when that happened, practitioners in Pennsylvania and companies and citizens all looked at it as if it had arrived in the Pennsylvania Constitution for the first time in 2013. That's how little recognized and understood the amendment was before that. So that's why we're paying attention to the text, because the text matters. So I want to walk through, and I've divided it into two parts, and so I'll take you through the first sentence, okay? Or I'll just give you an overview here. And basically what happens is the amendment protects environmental rights, and it protects and it greatly expands the common law public trust. And by doing those things for the people, for all the people, Article 1, Section 27 can be and should be understood as quintessentially about environmental justice, because it's about providing everybody the same level of protection. It's about providing everybody the same level of access to public natural resources. Now, that said, you should recognize the reality is that statutes and regulations do most of the work of environmental protection. In fact, I was at EPA's Office of Chief Counsel, General Counsel, on the day that this important National Law Journal article came out years ago about environmental justice, and there are all these puzzled lawyers saying, well, what are we doing wrong? What is this environmental justice thing? Doesn't the Clean Air Act protect clean air? Haven't we greatly improved air quality? Haven't we greatly improved water quality? And the answer was, not always. not in all ways and not to all people. And that takes me back to the universality of Article 1, Section 27 and its importance. So when statutes, when statutes have disparate effects, when statutes don't fully protect people's rights, under the new version of the old new version of Article 1, Section 27, the genuine version, under modern case law, courts can and have, as Meg pointed out to you, held them invalid. And when there are gaps in regulations, Article 1, Section 27 can provide backstop protection. Back to universality, and that's, I think, the common theme that you're going to hear from me. So take a look at this. This is the first sentence. And the thing to keep in mind here is if you kind of read Article 1, Section 27 all at once, it all looks like nice words. In fact, I remember as a young lawyer seeing the very same frame plaques that Meg talked about and thinking, these are really nice words. I wonder what it would mean if the courts treated them like law. When I wrote a brief on Article 1, Section 27, the brief would be, Article 1, Section 27 provides, quote it out, and then you get to the real law, which is the Payne versus Kasab test. Nobody ever looked at the text. So if you look at the text and you see that first sentence, and I'm not going to read it to you, notice there are no exceptions, and it applies to everybody. Everybody has these rights. There are Montana has something like this in its constitution. Hawaii has something like this in its constitution and enforces it. And now New York does. And that's really the end of it. Illinois and Massachusetts don't really respect those they don't enforce those rights judicially at all. Okay? And if you look at public natural resources, these are the second and third sentences. This is way broader. The common law public trust in Pennsylvania was about protecting access to navigable waterways, pretty much, and was confined to the bed and banks of navigable waterways up to the high water mark. And that was pretty much the public trust in Pennsylvania. And what this says is, well, no, look, we're not going to just focus on navigable waterways anymore. We're going to focus on public natural resources. And I'll show you in a minute, that's a big, big category. And it says that those natural resources are held in common by everybody, including future generations. And it imposes on the Commonwealth the duty to sort of all those public natural resources, to conserve and maintain them. That's a big deal. These are the people's natural resources, and the Commonwealth has to conserve and maintain them. So what does that mean exactly? Well, in the Robinson Township case, you can see in the top quote there that there's actually quite a lot of stuff. It's not just state parks and forests. It's air, water, including groundwater. I think you can fairly argue it includes pretty much critters who are not farm animals or pets, and all manner of other things. And it's a big category. Now, this isn't a plurality opinion. You can argue that it's dicta, but the Supreme Court has pretty much honored the scope of this so far. And Bobby McKinstry, a friend and colleague of mine, argue in an article you can see here that it really applies to, should be read to understand climate as well. Okay, so what does common property mean? Well, that's a really interesting question, I think. If you read this, it says Pennsylvania's public natural resources are the common property of all the people. Well, what does that mean? And I think in this context, common property can only be a property interest that is defined in trust terms. And what I mean by that is the Commonwealth, as the trustee, because they're made the trustee, has legal title, and the beneficiaries, present and future generations, have equitable title. How many of you have had a trust law class? Okay, yeah, there we go, a couple folks. If you have not, if you are still in law school, and this interests you, take the trust class. Take the trust class. That'll help you better understand what's going on here. There's an argument by the way, that what common property has to mean is total ownership. And the argument is used to limit basically the public trust in resources to state land and pretty much to state land, parks and forests and that sort of thing. And I explain in some detail on the slide why I think that's wrong. And the biggest reason I think that's wrong is it contradicts the public trust context in which this is all explained. The PEDF court and the Robinson Township court basically say you have to use traditional trust law. Once again, a reason to take trust law classes. And there's three different duties that Meg alluded to that I want to talk about a little bit here. Loyalty, okay, you're loyal, if you're the trustee, you have to be loyal to the beneficiary. That's it. You can't be loyal to other people. Impartiality, you have to, as a trustee, again, the state has to administer the trust with due respect for all the beneficiaries. And finally, prudence, the trustee has to exercise reasonable care, skill, and caution in protecting the trust corpus, that is, public natural resources. Now, what the Robinson Township Court said in two different instances concerning the shale gas legislation that was at issue there was that the legislation in two different ways had a disparate impact on beneficiaries. This was not about intent. This was about impact. It had a disparate impact on beneficiaries. Some properties are going to carry a heavier burden than others. In the one, and in the other provision, basically shut out municipalities to a large degree from even being able to appeal shale gas permits. You cannot do that. That's disparate impacts. And the other thing the court has been really clear about in a 2021 case, also a PEDF case, is that present and future generations are entitled to the same level, okay? They're on equal footing, they have identical interests. And so that really pushes hard against the grain of a lot of environmentally damaging stuff, which was, well, look, I'll operate in, I'm DP, I'll operate to do what I can for present generation, but future generations, let them take care of themselves. All right, so this is different. This is really different. So these are entitled to the same level of protection as other rights in Article 1. These are not baby rights. These are not second-level rights to say, property rights or the right to free speech. And I would argue, and Meg and Shirley gets this, as you heard her say, is that state agencies have a responsibility to enforce these. They shouldn't be waiting for people to sue them. I've got more information on Article 1, Section 27 on this at this particular link. Here's where you can find me. But there's one thing I want to just say in terms of applying this. There's a situation involving Chester. And here's some detail about this. This was about 20 odd years ago, something like that. And what you had is a superabundance of waste facilities located in an area that was overwhelmingly low income and black and minority. And what frustrated and what happened is there's litigation about this, and what kind of came out of this is, well, look, under the Equal Protection Clause, you don't get a violation unless there's intent. Well, there's no intent here. Under Title VI of the Civil Rights Act, you don't get a violation unless there's intent. Well, there was no intent here. It's just the way it worked, okay? According to the courts. Now, you can say there's a lot of other things going on. I'm not going to get into that. But here's what I think happens is this was before, all of this occurred while Payne versus Kassab was the law of the land, while Article 1, Section 27 was buried. If you could consider disparate impacts now, or then, if you could consider disparate impacts then, I think you begin to get a different outcome. If there's a duty of prudence then, as there is now, I think you get a different outcome because the agencies involved need to think about that as part of their duty, what their impacts are going to be going in. Not just the impact of a particular permit, but the impact of a permit on top of all the other permits that have already been around. And I say that, there's a whole lot more to be said here, but I say that to just leave you with this. There are ways in which Article 1, Section 27 can be used to fight environmental injustice. It's not a complete solution, but it's a tool in the toolbox. And I'll just leave you with that. Thank you so much.
We will now hear from Emma Bast. Emma is a staff attorney at PennFuture and a graduate at Georgetown Law Center. Emma's presentation will focus on the actions that can be taken in pursuing ERA enforcement, including important considerations.
Good afternoon, barely. Thank you, everybody. I'm Emma Bast from Citizens for Pennsylvania's Future, AKA PennFuture, because that is too much of a mouthful for modern life. PennFuture is leading the fight for stable climate, clean air, and pure water through legal advocacy, policy engagement, and empowering all Pennsylvanians to build sustainable communities and a clean energy economy for future generations. As a quick coda to some of the things my co-presenters have said, and a quick coda, brief digression from my slides, I think it's important to remember a couple of things. First, as Samantha said, environmental justice, I think it's really important as attorneys to be precise with the words that we use and to be precise with the definitions. That's our entire job, is to be really precise with the language. There has been kind of a linguistic shift in common usage of what environmental justice means. I think it has become coded as meaning black and brown. It's very important to know, like Samantha said, that's not true. Environmental justice also encompasses a lot of, it's about health impacts, it's about these sort of historic, cumulative impacts. There are a lot of white communities that are also environmental justice communities. I spend a lot of time in Carbon County up in Northeast Pennsylvania, and that's an environmental justice community, and it is as white as the day is long, just about. And they have a lot of legacy pollution. There's coal ash, there's acid mine drainage, there is, you name it, it's there. And so you have to be really careful when you encounter these things, to be mindful of what is there, that it doesn't diminish the impact of that. It doesn't diminish the fact that black and brown communities have often and statistically suffered more than white communities, that there is more wealth in many white communities than there is. And these things are measurable, and you can go to what is real and you can go to what is measurable and focus on that. I also want to add another coda on this idea that's been floating around about bureaucracy and environmental laws. And as Meg alluded to, these things came from somewhere. And they came because people were harmed. And they came because business interests recognized that it was bad for business and it was bad for industry if we didn't have a functioning environment. The Organic Act that created the national park system east of the Mississippi was passed in 1911 in recognition by a conservative banker from Massachusetts, in recognition of the fact that all the mills were getting flooded and they could not run business because there was so much ash runoff from wildfires because all the mountains had been clear cut. That is an over 100-year-old thing, recognition. This isn't novel, this isn't radical, this isn't new. This is old and is conservative, fundamentally little c conservative idea. So just with that, these things, these bureaucracies, these rules come from people getting hurt. They come from people dying. They come from a place that is real and grounded in the world. There are a lot of opportunities for legal and community advocacy. State, federal, local, most of the folks here are going to be familiar with all of those. And I want to highlight a few particular tools in the attorney's toolbox and also available to environmental justice community members. I think, and I'm really going to focus on local and state actions here. The federal government will always be there, we hope. But I think for purposes of kind of where community advocates and environmental justice advocates can focus their energies, you would be surprised at how much of a difference you can make and how much power you will have at the local and state level. First of all, a very kind of deeply underappreciated thing is when you're talking about meaningful involvement. If you are at the local level, you have a much more direct impact and much more direct interaction with your municipal officials. And fun fact, land use is deeply intersectional with a lot of environmental things. The state, our state laws capture a lot, but like others have said, there are a lot of things that it doesn't capture. To take an example that PennFuture has been working on, we have had calls for help with the build out of large distribution centers from across the state. These are distribution centers can be literally hundreds of acres big. That's 24/7 truck traffic. You've got hundreds, if not hundreds of trips an hour, thousands of trips a day, big 18-wheelers. There's a lot of obvious air and water pollution things there. And there are a lot of places where the last time a township or municipality updated their zoning ordinance, either updated where these things can go or updated the definition of what is a warehouse or a distribution center, was 1980. It was before the internet. No one had even conceived of you order something online and have it there that afternoon. And this was before there were places that didn't even have electricity the last time someone put in the definition of a warehouse. So these are the kinds of things where if you get that and you get that forward-looking preventative remedy, and you say, this is what a distribution center is, and they can only go in the industrial zoned areas of our town, you're not going to get a distribution center next to someone's on prime farmland, next to a residential community down the street from a school. And you avoid those air impacts by just keeping that from happening in that space in the first place. Anytime you can do that, you're going to get a better outcome. The other two things I'm going to be talking about, and we've already really, I'm going to breeze through it really fast. The other two main tools in the lawyer's toolbox are going to be public comments and going to be litigation. Effective public comments is a very specific thing, but if there's a final agency action, a permit for water, a permit for air, then the comment should be forward-looking, substantive, and strategic. They should try to narrow the gap between what the regulations look at and what community members want. Community members might want to stop something. So there might be someone who says, I don't like it, I don't want it there. You can certainly submit that as a comment to DEP, but that's not necessarily a thing that they're going to look at and say, well, one person doesn't want it, so we're not going to allow that. Unfortunately, for better and worse, that's not how our legal system works. Think about making it as substantive, as real as possible. Make it something that the department or any agency has to respond to substantively. What are the impacts? One of the tenets of environmental justice and community activism is that the communities know the land, they know the area, they know the history, they know who's there, they know what's there. What else should the agency know? Should they know that back in 1980, there was a company who worked entirely off the books that dumped all their waste on that site? That might not be recorded in the paper record. That's a thing that the department, that any agency should know. That's a thing that they have to respond to and consider and think about. Are they going to be stirring up a whole pile of asbestos that got dumped there semi-legally that maybe some of the folks who've been born and raised in the neighborhood know. These are things that should be known. What's the history? What are the impacts to the population? As you move along in the process, legal process, or maybe even before, think about, these are considerations for us as attorneys. Litigation in the advocacy and environmental justice context is fundamentally, it's a power shifting mechanism. It allows you to create a different paradigm where you can have either better negotiations or maybe make something be considered and realize that there is a use that is being proposed that should not be there. Who is your client? What is your goal? Are you trying to target a specific project, a policy, a law? Do you want to stop it? Do you want to modify it? What is your alternative? Is this use being proposed on private land in an area that is zoned for anything and everything with a zoning code that hasn't been updated since 1982? Is it going to be developed no matter what? Is that use that's being proposed that people don't like, can it be a little better? Can it be the better alternative? Is that land do you have a conservation? You've got someone who wants to buy the land and have it be conserved forever in the wings, and all you have to do is just get this one project to pull out. What is the goal? What's your alternative? What other factors are at play? Who's your counterparty? Is it a small business? Is it a big business? One of the things with environmental justice and with public advocacy and public interest advocacy is that there are a lot of interests that will simply outlast you. We see this again and again with environmental torts. People die before the litigation reaches its end. And it's a long time. That's just the nature of thorough investigation and our court system, and you have to know that. I know I'm a little over time, so I'll just breeze through things. Municipalities are also environmental trustees. They need to coordinate with PADEP or other agencies. I'm picking on PADEP here, but it'd be the same thing for any other Pennsylvania agency or entity. And the ERA authorizes and arguably requires additional scrutiny of impacts. The department, DEP, other agencies have to coordinate within themselves. You have to consider, what would you need to show? What evidence do you need to have to show that there's been one of the breach of one of those fiduciary duties that John and Meg were talking about earlier? Solely based claims, cases where there's just an ERA claim and not one of these other statutory kind of laws are uncommon. They're not impossible, but it's going to be a heavier lift. And there's one case where that was true, this New Hanover. This is a citation to the Environmental Hearing Board opinion, which is, it's long, but it is thorough and well-written. And I think for folks who are curious about kind of the role of the ERA in agency review, it's a great place to start, great overview. Lastly, in brief, what can environmental justice communities do? I think that's always the question. One of the most important things, like Sam said, stay informed. People might not know. You can information share, network, build your community. One of the hardest things to do is just get information out and know what's coming. But there are some public notice requirements, and a lot of people will still post just we remember in property law where you learned you have to go up to the fence post on the piece of property and nail in your public notice. You will still see that. So if you are in a community where people are there, they're on the ground, they can keep an eye out for that sort of thing, and they can tell other people and share that information. These notices do have to be put up there somewhere. So share information, stay engaged, talk to other people, recognize that it's work and share the load. I'm lucky that I get to do this as my full-time job. It is a full-time job to keep an eye on all of this stuff. And that's why community engagement, community organization, community organizing is very important, because one person cannot do it by themselves, and it's not sustainable to expect that. And that concludes my presentation. Thank you.
So at this point, we will invite the panelists up for our brief moderated discussion. We'll be setting up in just a few minutes.
I can move my stuff. Oh, my clock is still running.
Maybe this one?
Do you want to go here, Samantha? Triple one wire.
But from that side, you're on the left of it.
That last case that Emma showed on the screen that she said is a really good read is one of the cases we lost. So it's particularly instructive, just as a note.
Okay, thank you everyone for being here. We heard a lot of great information from each of your presentations. And this part of the panel is to synthesize and tie all that information together so that it can be as informative as possible to, let's say, a viewer. This is going to be posted on YouTube from an EJ community who are interested in remedying the environmental issues seen within their communities through the courts. So because environmental law can be very complex, difficult to understand, amorphous, in good old law school fashion, I thought it would be best to pose a hypothetical and frame our discussion off it. The hypothetical is this. There is a local city, and Chester has been brought up a few times today, so let's say it's Chester. The citizens of this city are already feeling overburdened by environmental hazards. They learn about a proposal for a new trash incinerator in the area. So that is the hypothetical. Does everyone understand? Okay. So my first question is about information, and Emma, you already touched on this, but I also wanted to hear from the other speakers to see if there's any other ideas. So before a problem can be solved, you must first know that a problem exists. What can residents of this city, Chester, go to learn that there is a problem, such as a proposal for a new incinerator?
Well, like, I started doing work in Chester in the, in 1990. And so I would say there's two, at least, well-established environmental justice leaders, community-appointed and self-appointed leaders. They are very different. They represent very different spaces. One is Concerned Citizens of Chester, which right now is run again by Zuline Mayfield. She ran it before. She left for 15 years. She's now back. The other is Reverend Stroud. Going to one of those two people as a community activist might be a good way. Don't forget your locally elected politicians. Don't forget your ward chiefs. Don't forget your mayor's office. But generally, I'd say in Chester, you're more likely to hear it from a local faith leader or one of those two.
Well, and I can speak to DEP, again, when a project like a waste incinerator, it's like it requires one or more authorizations from the department under one or more Pennsylvania laws. So it would be probably they'd have to submit a permit application. And when you have to submit a permit application for something significant, let's assume this is significant, it's not a small scale project. There are notice requirements in the Pennsylvania Bulletin. So the Pennsylvania Bulletin, even though it's dense, it's hard to read, it's really boring, it'll put you to sleep at night if you have insomnia, but it's where Pennsylvania DEP and people who want to undertake activities that require an approval from DEP, more than likely, again, if it's a significant project, there's going to be notice of that application. So it's before we even make a decision, there are a lot of times there's notices of those applications. That information, I think a lot of it is also can be found on DEP's website. I think each region, there are 6 regions of DEP. The Southeast region, I think, has its own web page where projects that are significant, I think you're able to get information about coming projects where we're still just either waiting for an application or reviewing an application. But I think it's a really good question. How do you find out? Because nobody reads the Pennsylvania Bulletin, right? So how do you actually find out? I think that's an interesting question.
I think there are also, I mean, some of it always ends up, I think that's where the community engagement thing really comes in. There are, wherever you are, Chester, I think environmental justice communities have also been organizing quite actively. But wherever you are, there are going to be folks who are keeping an eye on these things. And if you are somewhere where there isn't someone, then you can become that person. It really is that easy. And people, you should look to see, what's out there, who's organizing in your area, build on what's already there. Read the bulletin, read the news, read your local Facebook, whatever the town square equivalent site is, rants and raves or whatever it may be. And because people will notice things. They'll notice you notice strangers, you notice when someone starts sniffing around, and people wonder, hey, what's up with that? And there's a lot of value in information sharing just within your community, and as well as the official channels.
And the Pennsylvania Bulletin is online. You just Google Pennsylvania Bulletin, right? It's published every Saturday. So, and Pennsylvania Bulletin is notices of all the agencies. So you have to scroll down to Pennsylvania Department of Environmental Protection. And there'll be notices. There's a notice section, there's an action section, and probably some other things I'm not remembering, but.
Well, beyond that, just quickly, beyond that, one of the other permits you need is, you need an air permit, but you also need a municipal waste processing permit. The public notice requirements for that are not just about publication in the Pennsylvania Bulletin, they're also about publication in the local newspaper. The other thing I would say that's a little bit separate from that is that the DEP has an environmental justice policy that involves enhanced public participation. And I think there are mechanisms in that would provide other ways for getting access to information about that. And I think the final thing I would say is that project developers with a conscience, which is an important qualification, will often do outreach to the community prior to filing a permit application, try and get a handle on, is this okay? Where should we put this? What problems might you have? And that sort of thing. And I know, like, when I was a policy director at DEP 20 years ago, there was a proposal for an infectious and chemotherapeutic waste sterilization facility in what was clearly an EJ neighborhood, and they did that without notice to the community. And the community took that as a very large affront. And so in terms of paying attention to what current norms are for corporate behavior on this, it may very well be that before a facility like this would even be proposed, there would be outreach to the community. And if there isn't prior outreach to the community and the permit application is simply filed, I think the community would be reasonable, I think, in taking that as a red flag.
Thank you. So once the residents learn about this incinerator, we're sticking with that hypothetical, let's say they disagree with it being in their community. What are their options for stopping the incinerator from being built? In other words, who would they voice their concerns to?
I'll go first, but I think I'd really be interested in hearing sort of from an advocacy perspective, sort of how you approach that. But I think from DEP's perspective, again, the way to reach out, and John is right, there's a public participation, or an EJ policy that provides for enhanced public participation. And there are certain types of projects that are identified as triggering this requirement that DEP imposes on itself for enhanced public participation that we then facilitate. And I won't get into all the details, but let's assume that the permits that are needed for this kind of project would trigger that kind of enhanced public participation. Then you'd be working probably with the DEP. The Office of Environmental Justice has staff in each of the offices, and they're specifically assigned to do this work related to the environmental justice policy. So that would probably be the right person to start with in terms of how do I engage in this enhanced public participation, and that staff person would be able to facilitate which are the programs? What are the permits? When are the public hearings, right? That staff person cannot provide advice related to the technical input that you're going to need to provide. So what DEP has to evaluate the project based on very specific and detailed technical criteria, right? So one of the things you're going to maybe need to talk to the lawyers you're working with who are going to advocate on your behalf to the agency and to the permit applicant is, these are my specific technical concerns. You may need to hire somebody with that technical expertise related to the cumulative, the existing kind of cumulative environmental degradation, as well as what's going to be coming out of what are the air emissions, what are the waste potential problems. They might also need water permits. So there's a variety of types of expertise that you're going to maybe need to be able to, call upon to provide comments to the department, first and foremost about, do they comply with the regulatory requirements or not, right? That's your first question, right? Because that's the easier case. They don't meet the regs. They don't meet the statute. The harder case is, well, they meet the regs and the statute, but still it's an Article 1, Section 27 problem. I think that Emma alluded to that. But that's sort of, I think, how you work through it. This is, from an insider's perspective, I think that's how it happens, but I'd be interested in your guys' perspective.
See, to me, it feels like we just gave an environmental justice community a lot of work. You're working, you're trying to get your kids to go to school and do their homework on time, you're trying to pay your bills, and now we're telling you, in order to make the system work for you, you need to hire people, not just lawyers who you don't even know and you don't know where to start. And then you also have to get like a hydrologist, and you got to put in some air monitors, then you got to have someone explain it to you. And the reality of the situation is, I think we have to also have people do what they can do that's within their control. So again, I double down to having community empowerment, talking to your faith leaders, getting together as a group, figuring out why are the reasons you don't want it? Is it because you already have that many trucks and you can't take any more trucks because every time you're trying to walk your kid to the school bus, you're afraid you're going to get hit? That's a real legitimate issue that demands a traffic study, not necessarily an air study. So again, I'd say pull your community together, talk to within your community, what do we like, what do we not like? Did you know this was happening? Go to your faith leaders, the guys who own the independent stores, go to your high school principals, your middle school principals, try to get a groundswell, and then try to distill out what you're actually worried about that you can list that you know about now. And then try enlisting help. There are a myriad of groups out there that can help you. Don't forget your colleges and universities. I'm not just saying this because you're here, but don't forget your law clinics. There are kids out there that are dying to get experience, and God knows we all need them, right? So I think you need to think about first, because what I've seen so many times in 30 years of doing EJ as an ancillary duty while I ran other programs is that if we give work to people that are already doing 80 to 100 hours a week to put food on their table, they're not going to get to it. And then the facility rolls in. And one last thing, now that I'm on the wickedly other side of the table, don't forget industry. You would be surprised at the partnerships you can make with industry. I've been doing a lot of that since I got out of EPA, and I found really good corporate partners that are really interested. They don't want to go in a neighborhood where everyone hates them, and they don't want the bad press of talking about, in some instances, how everybody hates them. So think about partnerships, think about what's within your control, isolate and figure out what you need help on, and go for that targeted help.
Okay, we are short on time, so I'm going to ask one last question. There were a few other questions I wanted to get to, but let's just stick with this. So we heard from Meg earlier that the DEP's role is to protect the people in Article 1, Section 27 of the PA Constitution, yet they can be defendants in a case. So my question is, what evidence does an EJ community need to show to prove that the DEP or a government agency should not have issued the permit to build, in our hypothetical, the trash and incinerator, or to persuade the government agency that they need to do more?
So I'll answer first, but I think you make a really good point about it's given more people work. I think that the cases that we have lost, which again I think are instructive, right? So the New Hanover Gibraltar Rock Quarry case that Emma had on the last slide of her PowerPoint, that's a case where the municipality was sued, DEP and the quarry permittee together with some citizens. So it was citizens and municipalities suing DEP, and they had hired a hydrologist. But what was the most effective part of their case was the observation that in evaluating whether or not this quarry permit application met the non-coal mining statute, which requires the applicant to demonstrate they're not going to cause water pollution, that DEP had relied solely on the hydrology report submitted by the mining company and didn't ask questions or enough questions, this is what the Environmental Hearing Board said, about the Haska site that was right next door. Haska is the state version of CERCLA. So there's a hazardous site, a Superfund site, right next to the quarry, right? So one of the kind of basic things, me as a history major, I can understand this. To operate a quarry, you have to pump the groundwater, right? To pump the groundwater to be able to access the minerals that you want to be able to remove from the quarry, you're pumping the groundwater. Right next door, there's a hazardous site that's got contaminated groundwater. The groundwater aquifer was connected. So if you're pumping the quarry, you're pulling that contamination, right? The mining folks, the Environmental Hearing Board found, I think my colleagues maybe would argue there wasn't enough evidence about this, but what the Environmental Hearing Board found was the mining folks should have talked to the Haska folks. All these people are within DEP, and there weren't enough questions about, well, what's going to happen at the Haska site, right? So that was both an Article 1, Section 27 failing, right, as well as they didn't demonstrate. So what the township and the citizens' hydrology report indicated was there would be pollution that would move, and that the applicant's hydrologic report didn't accurately represent what was going to happen with the groundwater. I'm oversimplifying a lot of this. You know, I don't speak hydrogeologist, right? Again, history major. So, but you can understand that. Even as a sort of as a non-STEM person undergrad, I can understand that. You know what? That isn't prudent execution of our trustee duties, to not have the mining people talk to the Haska people, right? So that's an instance where the Environmental Hearing Board, and then it's gone up and down through the court system, and the Environmental Hearing Board was affirmed, concluded that the applicant didn't meet their statutory obligations and DEP failed in its trustee duties, right? So, but that evidence was the hydrologic report, but it was also the depositions and the testimony of the witnesses regarding, well, did you talk with this other person? That's not necessarily a heavy lift in terms of technical, no. You know, I'm oversimplifying again. This is hypothetically what those depositions look like. I wasn't counsel in the case. But, you know, that's a, how did you do your work? Who'd you talk to within the agency? A prudent trustee talks to all the people who would know stuff, right? So it's technical, but it was also kind of simple.
Yeah, I think that it's an illustrative case, but basically, you know, just at its most simple thing was saying like DEP knew, or a part of DEP knew that there was a toxic plume right next to where they were going to be pulling groundwater attached to people's water, which was going to move into people's water supply, and they didn't do anything with that knowledge. I think that the lesson there, and this is, you know, very generally speaking, is the department, is the permitting agency considering all of the information, and is it considering all of the potential impacts of whatever's happening, of our hypothetical waste incinerator? And I think it's about showing those impacts, about showing how it's going to be harmed. I think there is some degree of cumulative impact analysis that should be stronger and that the ERA authorizes. I believe Meg may disagree with me on the finer points of that. But there are also, you know, there's a bill right now in Harrisburg, HB 109, that was introduced to strengthen agencies' abilities to consider cumulative impacts and consider environmental justice. If it's a thing you care about, call your representative and tell them you support it and tell them to support it, because that is the kind of the flip side, which of all of this is that the Environmental Rights Amendment provides a backstop, and it also, I think, can help us identify where our laws need to be strengthened. That is an important part of this whole process, is getting better laws on the books in the very first place. As opposed to the specific question, what can people show? The exact things will vary, but it will be, you know, are there a lot of harms? Are there already 6 waste incinerators on this block? You know, is a 7th really going to push us over the edge? Looking at the whole block, not just this one particular plant. Maybe this one particular plant would meet all of its obligations, but you've already got 6. Maybe there's a truck traffic issue. So thinking about the details of this plant, whatever the thing is, in a slightly larger context.
If I can just add 1 or 2 quick things. The burden of proof in a proceeding like this is on the applicant. And typically, and that's the way the regulations and the statutes are written. And there's typically a set of criteria that the applicant has to meet. And some of those criteria are phrased in fairly general ways. Some of those criteria include references to Article 1, Section 27. And to Samantha's point, then, you go around to the community, and the community figures out what it really cares about, and it puts those issues, and you don't have to, in figuring out what you really care about, you don't have to, at least initially, have some big study. You can simply say, look, these are the issues we care about, show how you're going to fix them, and see how far that takes you. Now, sometimes they'll do a traffic study, and maybe you have to find somebody who can help you fight the traffic study. But often there are resources within the community, not one individual, but among a variety of different people, resources within the community or resources that can be accessed sometimes at least without charge or without significant charge, that can help you process and develop that sort of information. It's not a complete answer. For sure, an application like this puts a burden on the community, particularly if the community position is either no or not without modifications that would make it unacceptable to the developer. Under those circumstances, yes, it's a burden on the community just to have to fight the application. But that, I think, at this point is unavoidable.
Well, thank you all. Since we are out of time, I unfortunately have to end the conversation here, but I appreciate you all speaking here today. And this concludes the 2025 Environmental Law Journal Symposium. Thank you so much, everyone, for coming.